have you always qualified in every case that you have testified in as an expert?
There was one where the
Fight Child Protective Services and Win. I'm Cynthia Becker, and I'm here with attorney Vince Davis and our guest tonight, CPS defense expert Dean Tong. Hey, Dean, are you there?
I am. Thanks for having me this evening.
Awesome. Great. I'm glad that this all worked out. So, Dean, do you want to tell us a little bit about yourself?
Yeah, so I'm a forensic trial consultant, expert witness, author. I've been working cases against CPS across America for 25 years professionally. I've worked cases from all 50 states. I've testified as an expert in multiple areas of psychology and social science in 15 of the 50 states. And my website, abuse-excuse.com, has been on the internet for about the same time my professional practice has existed, about 25 years.
Awesome. And if anybody is interested, we did an interview. I interviewed Dean on the reality series, CPS The Horror Stories, and I have to say it was absolutely amazing and so informative with all the information that you gave, and our guest asking questions, and it was very...
Okay, Vince, I got you potted down. The number you just gave us, was that a landline?
And
No.
help answer...
That was your cell phone?
Yeah, let me give it to you again.
Okay.
310.
Yes, I just wanted to add a tidbit to the lady who called from Illinois who's at TPR trial that Mr. Davis was talking to over the phone.
Okay, I'm bringing you back up. Rachel's going to try and start texting you the callers, okay?
Okay, thank you.
I talked on a panel of experts about 20 years ago. I was invited to speak at the University of Chicago, and I met a lady by the name of Diane Redleaf. She is an attorney in Chicago. She runs a organization called the Family Defense Center, and the website is familydefenseconsulting.com. And she specializes in working cases like this lady's case, dependency TPR against DCFS in Illinois. And she also specializes in handling appeals, administrative appeals, where they put your name on the Illinois Child Abuse Registry. So the woman who called in may want to go to that website, familydefenseconsulting.com, talk to Diane Redleaf. She can tell Ms. Redleaf that I gave her the information if she'd like to, and I wish her well.
Thank you for that information. If she's not listening, I have her information. Her name is Ashley, and I'll be able to pass on that info for her.
Okay, good. Yeah, great. But yeah, sure, I'll be glad to take a call or two.
Great. Vince,
Yes.
do we have a call?
Before we do that, I wanted to ask Dean some questions. Dean, if I'm a listener and I'm just hearing you for the first time, what's a telephone number I could call you at? Or an email address?
Yeah, so my cell is probably my best number to reach me at, which is in Florida, 813-417-5362. But all my numbers are published at my website, abuse-excuse.com.
Abuse-excuse.com.
Right.
I love that name.
Yep. Alan Dershowitz wrote the book, The Abuse Excuse. I have the website.
Very good. Hey, have you done many cases in Southern California?
I have. I've worked a couple of cases with Art La Salento. Going back to 2008, Art and I worked a case from El Cajon. We worked a very litigious case up in Alameda County that lasted a couple of years. We battled the experts in that case. But yeah, sure, I've handled cases. I'm actually on a state paid case right now, a criminal case, where the state is paying my way here in San Bernardino. against the people of the state of California. That's an alleged physical child abuse case. So a lot of my practice is criminal cases. Obviously, I do take cases in dependency, TPR, Superior Court, as it's called in your state, family court. I helped a lady here in Daytona Beach win a case a year and a half ago here in Florida. Very, very embroiled case where the state spent about $300,000 to try to terminate her parental rights for allegedly falsely accusing the father of anal sodomy. And, you know, I was one of the experts who testified against the state in that case. We were fortunate to prevail in that case, and that case lasted 4 months at trial. So a very, very high conflict, protracted case.
So tell me, Dean, if I were a listener, a parent, and I, had a case coming up, say an adjudication and a disposition hearing, and I was charged or alleged to be a drug abuser, a domestic violence perpetrator, a physical abuse perpetrator, how would you help me and my attorney?
Yeah, so the first order of business is to get me engaged, and if you don't have the resources to engage in my services, then you would have to go through the court. As you know, counsel, the accused would have to prove financially that he or she does not have the resources to retain experts. So you would have to be gleaned in my state of Florida. It's called indigent for costs, or informa pauperis, indigent or poor. Get an order that you're indigent, and then the attorney can file a motion for my fees. And sometimes that goes to a hearing, sometimes not. And once there's an order established, then one of my little successful strategies over the years has been to assess the risk of the accused. So whether it's sexual abuse, physical abuse, psychological abuse, Munchausen by proxy, usually for a mother. Failure to thrive, failure to protect, whatever the issue may be, the referral issue that's being alleged by the government, I like to get the client tested. I like to run the accused through psychological risk assessment testing. So I have an expert who I've been working with for about 15 years. Of course, I'm not able to divulge that information for that expert on the air. But I've worked with several, but I've got one doctor in particular that I've had a lot of success with. And we've been successful in assessing risk, propensity, penchant to be the monster that the state is painting you to be. So I try to take the risk out of that equation by getting a clean bill of health for the accused through my doctor. And obviously that report, as you know, could be made admissible as a business record exception to the hearsay rule, or obviously if it comes down to a motion to eliminate that the state is filing, we can contest that at a in your state it was Kelly Fry. It looks like there's a case that came up in California called the Sargon case in 2015, which some of the judges in your state are now considering expert testimony to be daubert. So my state of Florida is daubert. I've testified in both Fry and daubert jurisdictions across America. I'm multi-published, so I usually don't have too much of an issue there. But so the doctor gets to defend his findings and opinions, obviously at that daubert or Fry hearing, and it also bolsters the accused's credibility. Credibility, as you know, counsel, is a huge issue. Only can be assessed by the trier of fact, the judge. So the doctor is basically trying, assuming the accused passes the test, of course, helping to kill two birds with one stone. You get a clean bill of health in your report, and then the doctor is obviously bolstering your credibility.
Very good. For some of our listeners, in California we use or have used Kelly Fry historically, and then you mentioned the federal case, Daubert. Could you explain to the witnesses the difference? Well, first of all, explain to them what that is and then what the difference is.
Yeah, so there were legal admissibility case law tests for people that are not aware. You cannot just testify to an opinion that you're a targeted parent and parental alienation is going on. That alienation matter of science can be contested by the other side, and usually would be. So a judge has the right to hold what's called a Kelly Fry or Daubert hearing, basically as the gatekeeper of the science to basically rule on science and controversy. And so it's going to be a battle of the experts. And obviously I'm for the defense. I testify for the defense mainly. And certainly the state has their experts. So Fry is a criterion by case law back to 1923, where the judge has to make a ruling that the entire psychological scientific community has accepted that area of science. So whether it's fingerprints or ballistics or parental alienation or risk assessment testing for alleged sexual abuse, the ABLE screen test, whatever the case may be, the judge has to make a ruling whether the science has been accepted by the general psychological scientific community. Daubert is more strict. Daubert is the more strict test because that requires the science to be peer-reviewed, published, have a known error rate, be scientifically reliable, and also what Fry demands, which is that the area of science be generally accepted by the entire psychological scientific community.
Okay. Have you always qualified in every case that you have testified in as an expert?
There was one where the court did not pass me way back in '08. It was a criminal case. The judge accepted my proffer but would not tender findings or opinions in that case. But ever since then, I have passed legal muster in every jurisdiction that I have, that a lawyer has put me up on the stand or
Right.
by Zoom. I haven't been physically in a court of law in a year. I did 7 cases by Zoom last year testifying. So,
All right. Hey, Dean, I need you to hold on. Cynthia, hold on. We got to take a break right now. This is The Secret, How to Fight Child Protective Services and Win. We'll be back with your calls, more questions and more stories and more from Dean.